Today, we're jumping into a neighborhood fight that actually went all the way to an administrative hearing. It's a classic homeowner versus HOA story, but what's fascinating is that the whole thing really comes down to the meaning of a single word: maintenance.
So let's start with the homeowner, Matthew Thompson. You can hear the emotion in this quote from the hearing, right? He'd bought into this idea, this vision of a beautiful, green, almost park-like neighborhood. But over the years, he watched that vision start to slip away as trees vanished and were never replaced.
So the big question is pretty simple when you boil it down. If an HOA's own rules say they'll maintain the landscaping, does that legally obligate them to replace trees that have died or been removed? Mr. Thompson sure thought so, and he actually filed a formal petition to make his HOA take action.
Here's a quick look at how it all went down. The whole thing kicked off in July of 2022. It led to a big hearing in December, and then a final decision came down just before the holidays. So let's get into what actually happened inside that hearing room.
The hearing starts, and right out of the gate, there's a curveball. The HOA's attorney, Beth Mulcahy, immediately moves to have the entire case dismissed. And their argument had nothing to do with trees. It was about whether Mr. Thompson even had the right to be there in the first place.
The legal idea they were using is called standing. And, in plain English, it just means you can't sue over a problem that doesn't directly affect you. You have to prove that you personally have been harmed in a real specific way.
So the HOA's argument was basically a three-punch combo. First, they said he lacked standing because, hey, there are no missing trees on his property, so where's the personal harm? Second, they argued he was suing the wrong people anyway, saying the tree rule was in the Master Association's documents, not theirs. And because of those two things, they said he's just not the right person to bring this lawsuit.
Now, here's where it gets really interesting. The judge, Jenna Clark, she could have just thrown the case out right then and there, but she didn't. She decided to hit pause on the dismissal motion, saying she wanted to hear the whole story from both sides first. And just like that, the real debate was on.
So how did Mr. Thompson make his case? Well, he didn't just talk about feelings or the vibe of the neighborhood. Nope, he went straight for the rule book, pointing directly at the words in the HOA's own governing documents.
This one phrase, this was everything. This was the heart of his entire case. It's right there in the HOA's rules, and to him, it's crystal clear. When a dead tree is removed, it's followed by subsequent replacement. He saw that not as a suggestion, but as an order.
Thompson's argument was that the HOA was confusing two different jobs. He said, look, maintenance is just the day-to-day stuff, like watering and trimming. But the documents also talk about having to preserve the community. And how, he argued, can you possibly preserve something if you just let pieces of it disappear forever?
And we're not talking about just one or two trees here. He came with receipts. He presented this detailed inventory, which he said he put together by literally walking the neighborhood with board members, and he identified 59 trees. 59 that were gone from the original plan. That's a huge change to the look and feel of a place.
All right, now for the other side of the story, the HOA board president, Charles Dean Otto, he took the stand and painted a very different picture of the rules and what the board's job actually is.
The whole case really came down to this. Thompson saw a hard and fast rule. A tree is removed, a tree is replaced. Simple. But the HOA saw it as a choice. They argued that maintenance gives them the option to replace a tree, but it doesn't force them to do it every single time. It's up to their discretion.
And this is the quote the HOA's lawyer used to really drive her point home. She pointed out that in the very same documents, when they're talking about the sprinkler system, the text explicitly says replacement. Her argument was pretty powerful. Look, if the people who wrote these rules wanted to make tree replacement mandatory, they knew how to say it. They said it for sprinkler heads, but they didn't say it for trees.
The board president also brought up some really practical issues. For one, these trees are on private property, so the HOA can't just show up and start planting without permission. In fact, he testified that a lot of homeowners have told him they don't want more trees. He explained that the board's policy is basically to only replace a tree if it's proven that the HOA's own mistake caused it to die.
So after a full day of testimony, legal arguments, and looking through all the documents, the case was in the judge's hands. Both sides had made their points, and now everyone just had to wait for the decision.
And the verdict was decisive. Matthew Thompson's petition was denied. The judge was not going to order the HOA to replace those 59 trees. But really, the final ruling isn't even the most interesting part. It's the judge's reasoning that tells the real story here.
The judge's final order laid it all out in 3 clear steps. First, she circled back to that initial argument about standing and agreed with the HOA. Since Thompson's own yard wasn't missing a tree, he wasn't technically a legally aggrieved party. Second, after looking at the rules, she found nothing that created a mandatory duty to replace every tree. And third, she confirmed that the trees are on private property and the HOA simply can't force a homeowner to accept a new one.
So what can we all take away from this? I mean, beyond this one fight in this one neighborhood, what does it teach us? Well, it's a fantastic real-world lesson about a kind of conflict that happens all the time in communities. This was a perfect clash between the spirit of the law and the letter of the law. Mr. Thompson was fighting for the spirit of his community, that park-like dream he signed up for. But in a legal hearing, the judge has to rule based on the letter of the law, the exact words on the page. And in this case, the language in the contract just didn't back up his claim.
And that leaves us with a really critical question, one that anyone who lives in an HOA should probably think about. When we agree to the rules, are we agreeing to the exact literal text, or are we agreeing to the bigger vision that text was supposed to create? This case makes it pretty clear that in the eyes of the law, it's the words on the page that matter most.